May 25th of 2020, I performed an evaluation in what could be considered a personal response to a Supreme Court's decision, Schlesinger versus Councilman 420 U.S. 738 1975. I did this because the decision in this opinion came on March 25th, 1975, and I had been following timelines of specific cases, including cases that I believe were used in derivative actions connected to my time as a school teacher in 2015 while I was outside of the United States. And so I had been trying to track this to see if, in fact, this was correct. And I do believe, actually, it does hold merit to say that things in my life, including acts of securities fraud connected to documents that would form a form of security, including a passport or a birth certificate, were actually coded to somebody's personal, private case law largesse, either in terms of cases they cited in their own personal efforts or other sort of benchmarks that had been set up in some sort of hedging strategy connected to their personal interest. And that during this time, cases specific to the court under Justice Berger were used in hedging strategies connected to my life while I was a teacher of minors in a private school in another country. I believe that one of those cases actually is concerning this case. But besides that, I believe this case speaks to information and understanding of matters ongoing at the moment. In the syllabus for the case, it says, after court-martial, charges were preferred against respondent Army captain for the sale, transfer, and possession of marijuana. He brought suit in federal district court to enjoin petitioner military authorities from proceeding with the court-martial. The district court granted a permanent injunction, and the Court of Appeals affirmed on the grounds that the offenses charged were not service-connected and hence were not within court-martial jurisdiction. This case speaks to considerations of what is considered to be within the jurisdiction of a military court and what would be considered to be in the jurisdiction of the federal courts system specifically. This man, so far as I understood, was an officer in the military who was accused of providing marijuana, which at the time was illegal, to a man who had identified himself as being enlisted and being a clerk in the military, but who it was revealed later was actually an undercover agent of the military investigative system. His contention was that was trying to establish what jurisdiction is. To put this bluntly and plainly, there is very different situation when one is going on under a military court system or military legal process than one is going on in a civilian court process or civilian legal system. And the distinction regarding whether or not the person he was selling it to was a clerk or whether the person he was selling it to was an agent involved in investigation is a material difference. If this was some sort of exercise that he understood he could justify under a military chain of command within an understanding that whatever his operationalization was within the military structure, could perhaps understand there was some sort of justification for attempting to distribute an illicit product or contraband to enlisted personnel that had been identified as somebody that would be involved with procurement or distribution, then there might be one consideration. But if that person was doing it in the form of an investigative agent within a sort of effort within the military to try to potentially identify some sort of crime or engage in some act of entrapment, and is a enlisted personnel as opposed to an officer, then there are different implications for that consideration if it is decided to be handled within the jurisdiction of the military court versus the civilian court. And if one reviews what happened in that case that day, that's exactly, both literally and metaphorically, what was being discussed by the court. This is why it is so important to ground in the legal process and the jurisdiction in which something is occurring. If you are simulating that you are in a military theater when you are engaging proxy scenarios domestically within the United States, and then you refuse to identify your affiliation and you refuse to quantify the specific jurisdiction, you run the risk of escalating it beyond your capacity to control or to handle in a legal and ethical manner. And if you're intentionally refusing to identify, because you already know you have every intention of doing that and are trying to escape accountability or culpability, then you need to be held accountable at the highest standard possible. Now, I had already declared to people while I was being detained that I understood that there was simulation of military scenarios that were occurring. And when I filed my reports, I expressed that I had concerns that what was happening was simulation of military process, and or that I or other people that I was with were being treated as if we were enemy combatants within the United States of America, but for whatever purposes, being subjected to policies and procedures that some would have already determined to be appropriate for non-citizens that were deemed to be enemy combatants. And as a result, questions of military jurisdiction come into consideration. And without any sort of effort to address that specifically, it is left possible to understand that a refusal to refute that is because the absolute express intention was for civilian interlocutors to attempt to assume a positioning as if they were qualified to engage in some sort of military action against a civilian within the United States of America. That is at the core of the request for new trial. And part of that is to assure that those that are in a role in the judiciary and in the legal system, including in the judicial branch and the legislative branch, are prepared to take responsibility for the power they have over the access to resources and other people's lives, and what it means to protect people that are being subjected to efforts to extort them into agreement to criminal activity.